Good morning and welcome to the California Board of Psychology quarterly meeting. We're happy to be here in San Diego. Who will be taking quorum today?
I will.
Okay, thanks, Ms. Burns. Could you please check them in?
Akoy-Badu, Bernal,
Here.
Kasuga,
Here.
Erickson,
Present.
Fu, Horn,
Here.
Jones, Phillips.
Here.
And you have a quorum.
Thank you. And I don't think there's much to say. We have a fairly packed agenda for this two-day meeting. We're probably going to focus primarily on action items tomorrow as opposed to some of the informational items. But in the meantime, we've got a very full day of petition hearings today, so with no further ado, I am going to ask for public comment for items not on the agenda. And if you could restrict your comments to somewhere to around 3 minutes, that'd be great.
Press the button. Thank you. Thank you for having me. My name is Connie Valentine, and I'm from California Protective Parents Association. We have been a nonprofit in existence for about 20 years now, and we are sort of the complaint department of the state. Parents call us when there's a problem in family court, which often involves psychologists. We've done some research through Dr. Staley, Geraldine Staley, which is on our website if you'd like to look at the cumulative data. We pulled out the California numbers out of 399 cases that were studied. We pulled out California, which was about 40% of the total. So I wanted to just give you a couple of pieces of data about what we've received as complaints about psychologists who are appointed to the court under Evidence Code 730. About 58% of the cases had a psychologist appointed for a custody evaluation. 58% of them were court selected, 9% of them were paid by the court. Mostly they were paid by the parents. They were required to be paid. And they charged up to $60,000 per evaluation, whether the litigants wanted it or not. The fathers paid almost 70% of the time. The other data were that 88% of the female litigants were domestic violence victims, according to their report. The evaluators had a much different idea from the litigants themselves about what was wrong with them. The mothers, we pulled out the mothers from this group. The mothers reported they were depressed 24% of the time. The evaluators said no, they were depressed 11% of the time. The mothers said that they had anxiety 16% of the time. The evaluators said no, they had anxiety only 8% of the time. The mother said they had post-traumatic stress and had been diagnosed by their physicians as having PTSD 16% of the time. No, the evaluators said no, they only had PTSD 5% of the time. There was a great disconnect there. Instead, the evaluators, the 730 Evidence Code 730 expert witnesses, said that the mothers had parental alienation syndrome 43% of the time. That does not exist in the DSM. They call them alienators 31% of the time. So over 70, almost three-quarters of the diagnoses were from these PhD psychologists were that the mothers were the ones that were raising abuse allegations incorrectly, and they were just trying to alienate the children from the fathers. They were also diagnosed as delusional 16% of the time. The net result was devastating. 73% of the California evaluators, this is excluding the rest of the nation, which were 38 other states. 73% of the evaluators in California recommended that the mother who had come to court to protect her child from abuse by the father lose custody, and that happened. 85% of the mothers in California lost total custody of their children or partial custody. The children ended up living with the person that the children said was abusing them, beating them, or raping them. This resulted in they thought would silence the children, and that did not happen. 73% of them continued to report abuse, and they were not heeded by anyone in the court system. I just wanted to bring that to the board's attention when they begin to look at the evaluator, the people who do custody evaluations in the court. They are not performing properly. Thank you very much.
Thank you very much. Seeing no other public comment, we'll move on to the president's report, which means that's me. I've just got to scroll ahead to get to the paperwork. By the way, if you see us looking at computers during the day, we're not playing Candy Crush or something. We're actually looking at the documents. We're on a Paperlate system for the board. Sometimes we love it, sometimes we don't. Let me see here if I can get it this way. There we go. Okay, I found what I was looking for. Okay, so first of all, we have the meeting calendar for 2018, which is in the package. If you're in the unified package, it's page 9. And that just gives you the dates that we have met this year. I don't know that there's that many more pending meetings on here. I don't believe there are. Just the strategic planning meeting, which will be taking place in December in Napa. So it is a meeting that is open to the public and is going to be publicly noticed. You're more than welcome to come to it. The agenda will be restricted purely to strategic planning and whatever other items we might pick up in terms of closed session items. Going to the 2019 board meeting event calendar, these are the dates that have been chosen and the general locations at which we'll be having our quarterly board meetings. You'll notice for the board meeting in April in Los Angeles that that's a 3-day meeting. Part of the reason for that being the fact that we do have so many petition hearings that it does prevent us sometimes from getting through our full agenda. So we thought we'd add a little cleanup on that one in hopes that we can kind of devote more time to action items and agenda items. And then as you go down the page, you see the other meetings that are currently scheduled. Committee updates, there are no committee updates. We are hoping for some new, for at least one new appointment to the board. And I know that for some of our board members, they're in their, what we call the grace year. So they'll be with us for a limited period of time after this. So hopefully there'll be people that are just as good that are appointed in their place, although that's a pretty heavy bar to get over, or high bar to get over. But hopefully we'll have more bodies so we're in a better position to staff our committees on a going forward basis and allow people that have asked for committee reassignments to actually get the reassignments. So at this point we're kind of static in the absence of a full board. And I think that's all that I have to report from the president's report. There will be an election of the president and vice president at the end of day number 2. We will be getting to that eventually, but certainly not yet. So, next item is the executive officer's report.
Good morning. Included in the meeting packet on the page 11 of the combined packet is the executive officer's report. On the agenda, the DCA annual report is listed. However, that report is not yet ready for publication, so that will be provided at the February meeting, and that's the annual statistical profile that has all of the licensing and enforcement statistics for the board. We have a staffing update included in the executive officer's report, and we currently do not have any staff vacancies, and this is the first time in a long time. So we're very happy, and we're hoping people stay and for a little bit before moving up and on to greater things. Also included in the meeting materials is the legislative update and AB 2958 by Assemblymember Quirk This has to do with teleconference meetings, so that's just included in your materials as a committee meetings, as kind of a heads up that bill did pass, but staff has evaluated the bill, and we don't believe that, given our committee and board meeting structures, that will be impacted by that legislation. So any questions about the EO report? Okay, thank you.
Thank you, Ms. Zurich. And the next item we have on the agenda is the DCA, Department of Consumer Affairs. We tend to use acronyms around here, so I try to remember. Department of Consumer Affairs Executive Update. That's actually, if I understand correctly, going to be moved to Friday, when there'll be a representative from the Department of Consumer Affairs here to join us. So that being said, I think what we're going to do is help to get the room set up for the upcoming petition hearings. There'll be 3 petition hearings. We will be breaking for lunch following the second session, or the second petition hearing. And at the end of the day, we'll be going into a closed session. Just for those of you that are planning your calendar for the day, closed session means that no member of the public can be in the room at the time that we meet. Discuss litigation matters, pending enforcement matters, and so on and so forth. That being the case, we'll go into closed session, we'll come back out of closed session, but we do that just purely for the purposes of adjourning for the day. So if you leave or you go take a nap while we're doing the closed session, you're safe in believing that we're probably not going to go back on the record afterwards. If that plan should change, I'll let you know.
On the record, in the matter for the petition for early termination of probation of Brian Cooey before the Board of Psychology, the record will reflect that there is a quorum of the board present. It's OAH number 2018-100-363, agency number 600-2018-000392. It's November 15, 2018, and my name is Mary Agnes Manazuski. I'm the administrative law judge assigned to preside over this proceeding. May I have appearances by the parties, please?
Good morning, Your Honor. Deputy Attorney General Tessa Eunice for the Attorney General's office.
Thank you. Sir, I need you to state your name, please.
Brian Cooey, Brian-Couey.
Great. And since you represent yourself, sir, what I'll just explain to you, as indicated in the packet of information that you got, the issue here today is rehabilitation and any changes or improvements that have occurred since the discipline. The purpose of the proceeding is not to rehash the discipline, but to give the board evidence of rehabilitation and mitigation. If at any time you have any questions, sir, or don't understand anything, please let me know, because I want you to fully understand everything happening here today, okay?
Thank you.
Any questions before we begin?
I do not have questions.
Thank you. Counsel?
Thank you, Your Honor. Your Honor, this is a petition for early termination of probation by Dr. Cooey. He has been on probation for 3 years of a 5-year term. He was placed on probation, but the decision became effective October 28 of 2015, and the decision and the statement of issues was based on 3 convictions dated 1997, 2000, and 2003. As I stated, he's been on probation for 3 years. According to the probation report, which is in the exhibits, he has met all the conditions of probation, and he now brings this petition for early termination.
Thank you. Did you wish to offer any exhibits, counsel?
I do, Your Honor. There's a binder before you. It has 7 exhibits in it. Would you like me to go through each one of them, or?
Yes, please, for the record.
Okay. Exhibit 1 is the notice of hearing. Exhibit 2 is the Board of Psychology guidelines for argument.
Could you speak up? We've got some noise going on upstairs. It's hard to hear you over whatever's happening upstairs. Or next door, I don't know.
Would you like me to start again, Your Honor, from the
exhibits, please. Thanks.
Okay,
Yeah.
Exhibit 1 is the notice of hearing. Exhibit 2 is the Board of Psychology guidelines for argument. Exhibit 3 is the certificate of licensure. Exhibit 4 is a certified copy of the decision and order. Exhibit 5 is the petitioner's petition for early termination of probation. I may stay at this stage, Your Honor. This is a bait-stamped and redacted copy. It's not the original. I do have the original with me in case the board needs to see it or would like it, but it's bait-stamped and redacted.
Thank you.
Exhibit 6 is a certified copy of the probation report. Exhibit 7 is a certified copy, of the probation file, the entire probation file for the petitioner. There is also an additional exhibit that has been placed before all the board members that is not the Attorney General's exhibit. It's the petitioner's exhibit, which he may choose to move in during his case. Just for convenience sake, we bait-stamped it also with the Attorney General's bait-stamped numbers, but it's not the Attorney General's exhibit. At this stage, Your Honor, I'd like to move in Exhibit 5 only for jurisdictional purposes. That's the petition, the copy of the petition.
Sir, any objection to my receiving Exhibit 5 for jurisdictional purposes?
And I'd like to
Wait,
move in
sir.
exhibits, sorry.
I need him to answer.
Are you seeking my?
Yeah, she's offering the exhibit. I'm seeing if you have any objection.
I do not.
Okay, Exhibit 5 will be received. And is the additional exhibit that petitioner brought today, is that the one that starts at AGO 254?
That's correct, Your Honor.
Okay, great, thanks. Okay,
And then I'd like to move in exhibits 1 through 4 and 6 and 7, Your Honor, for all purposes.
sir, any objection to my receiving exhibits 1 through 4 and 6 and 7?
No objection.
Those exhibits will be received. Anything further before I let petitioner testify?
Nothing further, thank you, Your Honor.
Sir, do you wish to testify in this matter?
Yes.
Okay. Why don't you move the mic a little closer because it is very loud over our heads right back here. And can you raise your right hand? Do you solemnly swear the testimony given in this matter is the truth, the whole truth, under penalty of perjury, the laws of the state of California?
I do.
Thank you. Go ahead, sir.
Thank you, Your Honor. Thank you, board members, for having me here today. I will take this time to talk about my rehabilitation. I'm going to use some notes. I wanted to do this kind of extemporaneously, but I have kind of a 15-year period that I'm going to kind of go over, if that's okay. So my rehabilitation really began in 2003. Is this okay, the volume, or? Okay, thanks.
Yeah, the noises are distracting, but
Okay.
your volume's fine.
So from around 1995 or 6 to 2003, I had a progressively worsening addiction, particularly to methamphetamine, and a variety of legal entanglements, which obviously the board is aware of. The most serious of which happened in 2003. So that prompted a brief stay in county jail, and then probation sentencing. And that probation sentencing, in a sense, identified that potentially my real problem was addiction as opposed to derelict behavior. So I was sentenced to 6 months of residential treatment at a program called Cry Help in Los Angeles. And that's really where my rehabilitation began. So after release from jail, I went to this program. It was a community-based setting. And for the first time in my life, I had access to professional help. It was a multidisciplinary team. I had therapy, group settings, and I was introduced to the 12-step programs of AA, or Alcoholics Anonymous, Narcotics Anonymous. So I completed that program successfully. So they took us to 12-step meetings daily. I obtained a sponsor. I began working my steps. And post-discharge from that program, I completed another 5 to 6 months of sober living, which provided me some additional structure early in my recovery. Also at that time, I was continuing on criminal probation, which lasted until 2006. So there was some random urine testing involved twice a month, fines and other things, but I complied with that, adhered to that, and completed that without issue in 2006. So being new in recovery, being on probation, I had some barriers towards reentry into employment, and in some sense, I was really trying to reenter the social contract. And so I began working in an apprenticeship program at a social service agency in 2003 called Center for Living and Learning. So that was an agency that helped disadvantaged youths, recovering addicts. I worked there for 3 years, and during that period of time, I went to 5 to 7 meetings per week. I worked with my sponsor. I had service commitments, 3 or 4 per week, and really just immersing myself in a recovery program. I'm not sure how familiar the board is with 12-step recovery, so if there's anything that's unclear, please feel free to interrupt and ask. Also in 2004, I wanted to begin to get an education. No one in my family had ever gone to college, so I signed up for community college, and I began training to become an addiction counselor. So that particular, it's more of a field than a profession, had some latitude with regards to people having records and so on and so forth. So I completed that training, got an AA, and then I got certified, and I began working at a chemical dependency treatment center called IADARP in 2006. IADARP, I-A-D-A-R-P. So I began paraprofessional counseling. I continued to work on my bachelor's degree. So I worked with, it was a community-based setting. I worked with lots of patients, adjudicated youth in the juvenile justice system, Department of Family Services patients. So never had any problems or issues. And at some point, I decided that I wanted to kind of expand my ability clinically, and that I would go to graduate school. And all during this time, I continued with my program, my recovery program. So for the first probably 6 or 7 years of my program, I attended probably at least five meetings per week, worked with sponsors. I've had 4 in 15 years. And went through the steps with all of them. And while at IADARP around 2008, it was suggested by my sponsor that I begin to seek individual psychotherapy. So some of the issues that I had experienced growing up were kind of outside the scope of the 12-step program, so I began individual therapy work with marriage and family therapist John Elliott. And over the course of 4 years, I would complete around 70 sessions with him. So that therapy was focused on attachment issues, relational issues, insight-oriented, solution-focused therapy. So really helpful, and really helped with my emotional development, helping with some characterological changes that needed to happen. And in 2009, I moved to another agency called Valley Women's Center, which I was a program manager there. And so that was a mental health county contracted substance use and mental health clinic. So I had some direct services, counseling. And there was a domestic violence program there and some other programs, victims of crime. So I worked as a paraprofessional for most of those years from 2003 to 2009. And then I made the decision to go to graduate school. I applied to the California School of Professional Psychology in 2009, the Los Angeles location. I actually did not get in the first time I applied, so I didn't get discouraged. I wanted to go to an APA accredited program. So I applied again, and the second time I got in. So I was completely thrilled and really excited to be able to be a part of the psychological profession, and I did very well there. I left with a 3.79 GPA, I did practicum rotations at county mental health clinics, one of them being Hillview Clinic, another one being Tarzana Treatment Center, and I obtained an APA internship, which only 23% of my cohort was able to obtain. I completed that successfully, and also during that time, I went back to therapy again. So from March to August of 2011, I saw Dr. Stacy Berlin for a total of 24 sessions, and then locations. So frankly, I was really excited to get a settlement, and pleased to know that there was a path to licensure for me, and I was completely willing to do whatever it took to prove myself to the board. On some level, it was disappointing. I mean, I had 10 or 11 years sober at that time in recovery, but I just kind of practiced the principles of the program, acceptance and humility, and understood that if I ever wanted to be licensed, that this is what I needed to do. So I was really determined to adhere to probation flawlessly to the best of my ability. And it's been a little over 3 years now. I have done that. So I have never missed a check-in for testing. I'm probably approaching 1,000 check-ins at this point. I have never missed a test. I've never tested positive. I have never been late on a quarterly report. I have never had a negative report from a monitor. I've actually had 2 separate monitors. And so it's a lot of work, but, I volunteered for it. So I'm real proud that, I have a really strong showing with probation. And I understand now that I'm eligible to apply to have it terminated early. And in order to have that done, it's my responsibility to clearly and convincingly, express to the board, why I am rehabilitated. So let me see what else. A couple of documents that I submitted. I don't know if they're labeled or not.
Is that the new sets? Sure.
Yes.
Okay, I've marked that Exhibit 8.
Exhibit 8? Okay. So I try to provide just some minor documentation to substantiate my testimony. I didn't want to overwhelm the board with letters, and I understand letters, anybody can write anything, so I don't know how much weight that carries. But prior to my administrative hearing, I had submitted myself to a psychological evaluation at a Fitness for Duty, with the Fitness for Duty assessor, Dr. Greg Skipper. I submitted to a hair test, urine screen, to provide some objective evidence of fitness to practice, and his determination, if you would look at that exhibit, is that I would be safely able to practice with the public. Subsequent to the probation, I also submitted to a psychological assessment with Dr. Alan Karbelnig, the board's assessor, and I'm not sure what AGO number that is. But similarly, my understanding is his determination is that I would be safe to practice, and that there were no underlying issues of pathology that would cause me to be compromised in any way. And I do still have a diagnosis of a substance use disorder in full remission, and I will have that diagnosis for the rest of my life. But for 15 years, I have not had a drink or a drug. My sober date is July 3rd, 2003. That's the date that I entered the Cry Help program. I probably had a couple days sober before that, but I really picked that day as the date I really committed to this lifestyle. I'm a very traditional person within AA, so I don't take opioid medications, I don't take benzodiazepines. I try to cope with things adaptively with things like exercise or other strategies. I mean, not that if I was injured I wouldn't take those medications, but I'm very cautious about my recovery. I protect it. It's the most important thing in my life. Getting sober is truly the greatest thing that I've ever done, and I mean, to go from being in county jail, homeless in a treatment center, to being in front of the board today, I mean, that's not a miracle. I don't know what is. And it's all because of my program and my sobriety. Let's see. I think that's about it. So ultimately, I just, currently I probably attend 2 to 3 meetings per week. Weekly contact with my sponsor. I submitted a letter also in that exhibit from my sponsor indicating that I have a sponsor and that he works with me. And I'm still of service, so I have what's called a literature commitment, which is I bring literature to a meeting of I apologize. I have commitments in the 12-step program. One of them is a literature commitment, which means that I bring literature to a Cocaine Anonymous meeting on Fridays. I also do area service work for Cocaine Anonymous currently. And so I'm what's called a delegate. So I do some area stuff and kind of link San Diego's fellowship to the larger region. I've had many commitments over the years. Being of service is a really big part of my recovery. My recovery program basically consists of 5 things. I go to meetings. I work with the sponsor. I work the steps. I be of service, and I have a higher power of my own understanding. So that's kind of the bedrock of my recovery program. Professionally, I'm a very, I guess the word would be prudent person. I understand there's a lot of pitfalls. I avoid being overconfident about my skills or abilities. I'm a member of professional organizations like APA. I go to a lot of training. I pay attention to legislative changes, legal ethical interface. I understand how careful a person has to be in this particular profession, more so myself because of my history. I don't think I'm at no risk, but I don't think I'm at any more risk than maybe anyone else who's not on probation, just being honest. There's always a risk of relapse, there's always a risk of problems. But I have been sober for over a third of my life, my late 20s, all of my 30s, and my early 40s. And if I continue to do what I'm doing, I think I will continue to stay sober. I believe my sobriety is kind of a daily reprieve, as they would say.
Thank you, Your Honor. Kui, you said your probation, your
and I think I might have been around June 30th. I did not pick that as my sobriety date because I wanted to have a really honest and clean start to my sobriety. So July 3rd, when I went into Cry Help, is the date that I picked, that I committed to it. But I probably had a couple of days, between June 30th and July 3rd. But, before I came into recovery, I didn't realize a beer was not being in recovery. But I disclosed that to the treatment program, and they said, actually, you should probably pick a later date where you're actually sober, and I was happy to do that. So that's the explanation.
Thank you. So your sobriety date is July 3rd of 2003. Does that mean you've had no relapses in the last 15 years?
Correct.
How many times have you worked through all the steps?
I've had 4 sponsors. 2 of them I've gone through the steps twice, and 2 of them one time. So if I can just elaborate a little. So that's the formal, in sequence, working through steps. Generally, at my period, my development and my sobriety, I'm considered to, or expected to apply the steps in my life on a daily basis, including the principles behind them: honesty and faith and hope and surrender. And generally, I see myself as being in what's called the maintenance steps, which is 10, 11, and 12. So that's continuing to take personal inventory, connection with higher power through prayer and meditation, and carrying the message. But formally, I would say 6 times over 15 years.
Thank you. And I'd just like to ask you about your 2 monitors. I see you've had 2 practice monitors, and they've both been based up in LA, correct?
That's correct.
And I looked at the first monitor. Maybe you can help me with his name, Dr. Bafar.
Dr. Bahar Safai Far.
Right. Would you like to spell that for the record?
Bahar, B-A-H-A-R, Safai, S-A-F-A-E-I dash Far, F-A-R.
And I saw on his report it said that you weren't seeing any patients, or there were very few patients and files reviewed. He gave you a good report, but there are no, maybe 1 or 2 patients seen or files reviewed. Then you saw the next monitor, and his name is?
Dr. Matthew Polachek.
And can you spell his last name for the record?
Polachek.
Okay, and he's your current sponsor, correct?
Current monitor, yes.
That's right, monitor. And according to his report, he's reviewing lots of patients and lots of files.
That's correct.
Can you explain the difference, why the one practice monitor wasn't reviewing patients and files and this one is?
Yes. So initially, when my application for registration was approved and approaching the activation and probation, I was told that I had to begin working very quickly. So Dr. Safai Far runs a group practice in Tarzana, California, so that she's the first person who would agree to supervise me, employ me, and monitor me. The volume of that practice for me was very low. I was working also at Valley Women's Center as the program manager at that time. So essentially, just basically to keep the registration active, I was practicing in her private practice. And then when I went to the Betty Ford Center, I had the opportunity to complete hours in an agency setting. So with that, the volume is very high. So a combination of individuals and groups and assessment opportunities. So at some point, I believe in January of 2017, Dr. Safai Far sunsetted her registered psychological assistance. And then I went completely to Dr. Polachek, and my registration numbers were combined. But it was a matter of pragmatism. I had to find a place to work very quickly. So that's why I worked at the private practice, and there was a very low volume.
And how much time do you spend working up in the LA Betty Ford Clinic, and how much time are you here in San Diego?
I'm at the Betty Ford Clinic once a week in Los Angeles, particularly meet with Dr. Polachek. So it's one agency, so it's a shared record system. Patients are exchanged. The majority of the service provision that I engage in now is in San Diego. Initially, the majority was in Los Angeles, so that's kind of flipped because now I have a leadership position in San Diego. So that's where most of the patients that I see are. So Los Angeles, 1 or 2 patients during the week, particularly on Saturdays. But San Diego, it can be, if I'm doing a group session and doing record keeping for that, I can see as many as 10 to 15 patients in a week. I typically carry a smaller caseload as the site leader, so between 3 to 5 patients on my caseload that I'm responsible for individually. But There's also some varied duties, so sometimes I will be doing some suicide assessing or other types of single unit services throughout the week for patients that may not be assigned to me. But we have the same record system, he has access to the system, so he is considered my supervisor within the agency.
So, as you say, you shared records, so the fact that he's in LA doesn't prevent him from also reviewing your San Diego patients and records, is that right?
That's correct. So we have a proprietary record, electronic health record system that has access to all sites and all charts. So and besides our weekly supervision monitoring, we are together in trainings frequently. We go to each other's sites, speaking on the phone, video conferencing. It's pretty frequent, our contact.
Thank you, and I have no further questions.
Thank you. Do any of the board members have questions? And if they do, if you could state your name first so the court reporter can record who's asking the question. Dr. Horn?
Jacqueline Horn, Jacquelinehorn. So, Dr. Cooey, I have one question for you. Have you finished your postdoc hours? You said you had gotten most of them in one place. And so, where are you in your process?
My postdoc hours are complete.
Okay.
So if I have, my intention if I am terminated early is to take the CPLE and the EPPP as soon as possible. To take the California ethics exam and the examination in the professional practice of psychology as soon as possible. I was hoping to not have the probation transferred if I were to pass. But my postdoc hours are completed. I believe there's a window too that those have to be done, and I think it's with 30 months or something like that. But yeah, they're done. I mean, I'm just continuing to work under that registration, but the postdoc hours are completed.
Okay. Thank you.
Good morning. It's freezing up here. Gosh, it's cold. I just had a really quick question in terms of if this were approved, do you see yourself sharing part of your story with your patients, or do you do that often? Do you do that now?
I'm very judicious with self-disclosure. So I think when I began as a paraprofessional counselor, my status as a recovering person, I think if I did over-disclose, was because I lacked the clinical skill to really develop alliances correctly with patients, because I think oftentimes in treatment, patients see similarity as trust, which is really not. But occasionally, if it's for the benefit of a patient, I will engage in a very conservative, judicious disclosure, but I generally do not employ that as an intervention or some mechanism to develop alliance. I'm in the recovery community. I'm pretty known. That's one of the weird things about probation is I have lots of meetings. I know lots of people in recovery, lots of people work in the profession, and I'm showing up to a meeting with an attendance card, which is kind of weird for people. And so I kind of explain that to them. But if patients ask me, I'm happy to disclose. They obviously are informed that my probationary status and that someone's going to be examining their records. But in general, I don't just volunteer that unless it's helpful for them.
Thank you.
Hi, Dr. Cooey. I'm Dr. Stephen Phillips, Stephen Phillips. I just had a couple of questions for you. I think you were pretty thorough in your presentation and appreciate the fact that you've been in recovery so long. I'm in recovery myself, so.
Oh, okay. Well, thank you for telling me that.
Absolutely. I don't disclose it to my patients generally either. They generally don't watch these webcasts either. So. I did want to ask you, there was question number 5 on your petition.
May I have the AG number, please?
The AG number would be 0034, the particular page I'm referring to.
I see it.
Okay. And I'm looking in particular at question number 5. It says, how do you think your actions, inactions, or issues that led to discipline may have affected patients and/or their family members? And you quite appropriately answered that you weren't seeing patients at the time that much of this was going down. How did your actions affect other people, the actions that were the basis for us being concerned?
Great question. I actually saw that question and called the monitor and asked for clarification because I wanted to be concise when answering the question. But my actions devastated my family, both my parents, and the assault was with an uncle that I got in a fight with. It really injured our relationships, and globally, I was a derelict person who really did not contribute anything to society, and was probably a drain on both the resources of my community and others. But, my parents passed away, both of them last year. My uncle passed away this year, and I have some siblings as well. And I have had, at that time, 14 years to make amends for those things. And so in some sense, I had a tremendous amount of gratitude to have had the opportunity to be there for my parents. That may sound bizarre, but I am nothing but grateful. I don't necessarily regret what happened in the common sense. I understand, as the program would tell me, that I can see how my experience can benefit others. But to answer your question, yes, I hurt many people. What I did was very egregious, and it took me many years to work through the shame of that, to be honest and accepting of that. And at this point, Maya Angelou said back then, I did what I knew, and when I knew better, I did better. When I had the opportunity to get help, I felt for the first time in my life hope, and that I was going to get a second chance, and I was determined to ensure that I would not need a third. And everything I've done in my recovery has been to make up for those things. There have been times in my recovery where I wasn't sure if I wanted to stay sober, but I thought of my family. I thought of, am I truly sorry for what I had done? I learned, the best apology is changed behavior. And later on in my recovery, I was able to take care of my parents as they became sick and ill and passed away, to be there for my family. My family eventually accepted me back. It was several years before that happened. And I certainly had some things I could control with that and other things that I could not, but I simply did what I was supposed to do and took the next indicated step in my life. But yes, there was a lot of damage to a lot of people.
Why do you...
I just need the record to reflect that board member, and ma'am, I'm going to butcher your name, so if you want to pronounce it, please. Okay. Just arrived while Dr. Cooey was testifying at this last answer, and because of that, ma'am, you may not participate in the deliberations or in this proceeding, and when we go into closed session, you will participate. Okay. Thank you. Go ahead, sir.
Why do you think we placed you on probation?
It's your responsibility to do so. So the Department of Consumer Affairs, the Board of Psychology, your job is to protect the public, to ensure that no harm comes to patients or consumers. And I understand why that had to be done. To be perfectly frank, this is why it was so easy for me to accept. When I went to treatment and therapy, those experiences changed my life. I shudder to think if I had been sent to the wrong person, if I had been sent to somebody who was incompetent or impaired, the entire trajectory of my life would be different today. And so I understand how important that is. Because everything I have today is because the right people took care of me and treated me. So in a personal sense, I hold that as a value. I understand that, in our profession, being of service to the public, having the opportunity to be of service, is not just noble, but has to have safeguards. And, you know, if I looked at my history, right, sometimes the greatest indicator of future behavior is past behavior. I probably would not have licensed me at some point earlier on in my sobriety either. So again, I was, you know, just in some sense, very grateful that I even had a chance or a path to become licensed. I took the chance that would never happen. So again, it's just gratitude. But I don't know, I kind of took you around the block to cross the street, I'm sorry.
No, that's fine. That was responsive. Thank you very much. I don't have any further questions.
Thank you. Sir?
Good morning, Dr. Cooey. For the record, can you see the spelling on my name? Michael Erickson. I think you've given us a thorough overview and explanation of your history. I'm wondering if you can think of something that was not brought forth in your history that is relevant that we should know about, or is there something that would be relevant for us to ask that maybe has not come to our attention that would be a factor in considering whether to terminate your probation early?
There were probably, I mean, it's over 15 years, it's hard to kind of, for me to identify, you know, what is going to be relevant for the board, and I kind of just left it to the questions to clarify anything that was, you know, uncertain or unclear about myself. I understand kind of objectively what the criteria is, state of mind, factual rehabilitation, and the criteria set forth by the state and the legislative branch. But, I mean, one thing I'm surprised you haven't asked is, you know, what would happen if I relapsed, or, I mean, I've kind of expected to hear that, but other than that, no, I can't think of anything.
We do have one board member left.
Thank you for your assistance with that. That would be my question. What would happen?
Okay. So for me, relapse is a process, not an event. So it's, you know, something that for me is an artifact of both vulnerability and becoming compromised in some way. I mean, I haven't had cravings probably since my, you know, first maybe 1, 2, 3 years sober. But I think, you know, some of the dangers for me is complacency, getting away from meetings, you know, not being honest with my sponsor. And you know, this comes from just my observation of being sober 15 years. And so I think, you know, if I felt as if I was going to relapse, I would probably already be in a heck of a lot of trouble, meaning that I haven't been taking care of myself, or, and, you know, it's hard to say how I would, I hope it never happens, and my whole life is designed to work towards that never occurring. I'd probably say 90% of my social relationships are with persons in long-term recovery. I go to lots of meetings, like, you know, I recreate with persons in recovery. My wife is in recovery. And for me, it's a wonderful lifestyle. It's a terrific template for who I am. It's given me all of the tools to live life on life's terms, as they would say. And so I get a tremendous amount of esteem from helping others, from modeling for other people and other professionals. But again, I think the short answer is, you know, I don't stop doing the work, and I probably won't relapse. So.
Thank you. No further questions at this time.
Thank you, Doctor.
Hi, Dr. Cooey. I'm Dr. Cheryl Kasuga for the record. Good morning, and I just want to commend you for 15 years of sobriety.
Thank you.
My question is related to Dr. Erickson's question. You mentioned earlier that when you feel vulnerable, you seek psychotherapy.
Correct.
And I'm just wondering, if you can share what were those moments that you felt a little vulnerable that made you seek psychotherapy in the past?
Sure. Good question. So initially in 2008 was primarily just at the direction of a sponsor. So that was more deconstructive work, trying to develop some
With all the board members? Okay. On the record, in the matter of the petition for early termination of Lori Love, PhD, OAH case number 2018-100-334, agency case number 600-2018-000-493. My name is Magnus Matazuski. I'm the administrative law judge assigned to preside over this matter here in San Diego on November 15, 2018. The record will reflect that a quorum of the board is present. May I have appearances, please, beginning with the agency representative.
Good morning, Your Honor. Deputy Attorney General Christine Rhee on behalf of the people of the state of California.
Thank you. And ma'am, state your name, please.
Good morning, Dr. Lori Love.
Okay. Ma'am, since you're representing yourself, I'll just remind you that pursuant to the instructions given to you by the board with the packet of information, the issue here for the board is rehabilitation and any changes in behavior since the discipline was incurred, and is not here to rehash the facts of the prior discipline. If at any time you have any questions or don't understand anything happening here today, please let me know because I want you to fully understand everything, okay?
I understand.
Okay, any questions before we begin, ma'am?
No.
Thank you. Ms. Rhee?
Your Honor, I'll just briefly start by giving the board a timeline of the events in this matter from 2010 to 2014. That was the petitioner's involvement as the parenting coordinator in the original complainant's family court matter. And from 2010 to 2013, the petitioner was also the 2 minor children's therapist in that case. The board filed its accusation on September 14th of 2016, alleging the following: repeated negligent acts in assuming professional work with parents and their children, assuming multiple roles as a parenting coordinator and an individual counselor for approximately 3 years, failing to document informed consent showing that the petitioner would be doing the parental coordination and individual counseling for the minor children, and failing to obtain proper authorization to release information about the father and the children to all parties' attorneys in a format that could be admitted directly to the court and be a public record. Correspondingly, the accusation charged the petitioner with violating ethical standards relating to multiple relationships, informed consent, and maintaining confidentiality. A decision in order was issued by the board on April 13th of 2017 to be effective on May 13th of 2017, where Dr. Love's license was revoked, revocation was stayed, and she was put on probation for 2 years with the following conditions: practice monitor, successful completion of the California Psychology, Law, and Ethics examination, coursework, an ethics course, cost recovery in the amount of $16,000, and the standard terms and conditions of probation. The board received the petition requesting the early termination of probation from Dr. Love on May 18th of 2018, which is just after the year mark of the start of the petitioner's probation. And so at this hearing, since the burden is on the petitioner, I'll wait for the petitioner to present her case and for the opportunity to ask her some questions before providing the Attorney General's recommendation. And at this time, I would be asking to enter in the exhibits that have been provided to you.
And for the record, those are exhibits 1 through 6. Dr. Love, any objection to my receiving exhibits 1 through 6?
None.
Exhibits 1 through 6 will be received. Ma'am, it is now your opportunity to testify. Can you raise your right hand? Do solemnly swear the testimony given in this matter is the truth, the whole truth, under penalty of perjury, the laws of the state of California.
I do.
Thank you. Can you state your name for the record, please?
Lori, Lori, Love, Love.
Thank you. You may tell the board what you'd like them to know.
Yes. Good morning. I have been on probation for 1 year and 6 months of the 2-year term. I was asked to have a practice monitor. While anxiety-provoking at first, it actually was a great experience. I still speak with her, and we continue to meet on a monthly basis. Child custody and visitation work can be a very isolating experience, and I've enjoyed having a consistent resource. I was asked to take the CPLEE exam. I did so and passed that. I was asked to complete 12 hours of coursework, and I have completed 58.5 hours of continuing education, not because I was required to, but because it is very important to me in my ongoing work in this field. I've never worked so many hours in my life over the last year and a half, and have been able to pay all of the probation costs, as well as the $16,000 in cost recovery. I have obeyed all laws, have not even had a parking ticket, but that really didn't require any effort or change in my behavior in the way I conduct myself as a citizen. I've completed my quarterly reports. I have not had any changes to my employment except for increased hours per week. I am the only Latina in San Diego County that works at this level in the field of child custody and visitation. I understand that I have an obligation to my community to adhere to the highest ethical standards and to provide the services that the majority of psychologists don't want any part of. In terms of multiple relationships, I'm very clear and I understand that when a psychologist has 2 roles with the same person or family, it can possibly impair the psychologist's objectivity, competence, and effectiveness. It's abundantly clear to me that the APA has explicit standards that do not allow any blending of roles as a parent coordinator. In terms of informed consent, I have completely revamped my procedures regarding informed consent in court-ordered custody evaluations, as well as for the other services that I offer. I send the informed consent, limits of confidentiality, and procedures to the attorneys so that they may go through the information with their clients first. I also understand that it is my ultimate responsibility, so I provide the same paperwork in the waiting room for clients to review, knowing that all attorneys won't necessarily take the time to review paperwork with their clients. Then, when they start the session, we verbally discuss the paperwork. I make sure there's a signature, and I remind them that if they have any concerns or questions, this is not the last time they have to talk to me about it. They can bring them up at any time. I keep them now in a paper file. We have a computer scanned file, and I've also purchased a Carbonite backup system. In terms of confidentiality, I've instituted a new privacy policy that allows clients to opt out of various forms of communication completely. And it's not that they couldn't otherwise, but it's very black and white at this point and clear. Letters that I write to the court are only written at the request of the clients and/or by court order and with the client's consent. I no longer sign letters under penalty of perjury on a regular basis, and the reason for that now is to protect my communications from potentially being misused. The ethics courses were helpful to me, but the most valuable ongoing resource of which I became aware was that my malpractice insurance actually provides a free resource for any questions or concerns that I might have. All I've had to do is call, and they set me up with a free consultation with an attorney, and that's something that I was never aware of. I work in a highly litigious field of psychology. I have done so for over 20 years and have never had an issue until this time. I will continue to adhere to all of the standards and guidelines vigilantly. Thank you.
Dr. Love, when I was looking through your probation file, I saw that you might have submitted one quarterly report late. Do you recall that?
I do.
Okay. Can you tell us the circumstances of that?
I mailed it and it did not get there. He told me that he had not received it, and from that point forward, I both mailed and emailed.
Okay. And you've paid your probation monitoring costs up until, was it the last fiscal year?
Through 2018.
Okay. I wanted to talk about the case that's in the accusation a little bit. If I can refer you to Exhibit 5 in the binder. And the Bates label is AGO-033. Let me know, are you at that page?
I think so, but it doesn't look the same as yours.
I think it does. Is it the?
Yes.
Okay. So in this page, AGO-033 and AGO-034, which is the next page, I think you give an explanation as to the events that led to your discipline. Is that correct?
I believe so.
Do you remember filling out these forms?
I do.
Okay. And you said on the first page, AGO-033, when asked to describe the events that led to the discipline, that's question 1, that when the rules came out for parent coordination from the AFCC, you did not terminate the dual roles immediately. Do you see that part?
I do.
Were you referring to the guidelines from the AFCC from 2012, or were you referring to the APA parental guidelines?
Well, now that you mention it, it's the relevant to this case and what happened. It would be the APA standards for parental coordinators.
Because the APA standards came out in 2012, correct?
Correct.
Okay. And I think the AFCC standards came out in 2005, is that correct?
They were guidelines in 2000. Yes. Yeah.
Okay. And so the same question on page AGO-034 on the next page, you refer to the AFCC guidelines. Did you really mean to refer to the APA guidelines from 2012?
Yes.
Okay. Now, in the case, in the accusation that was filed against you, do you agree that you had dual roles in your involvement in this family court case?
I do.
Okay. Do you also agree that you didn't document informed consent showing that you were going to be a parent coordinator as well as a therapist to the minor children?
I do.
And do you agree that you failed to obtain proper authorization to release information about the father and the children when you wrote letters to the court?
I had authorization to send them to the attorneys, and that is who I sent them to. It was filed with the court, and I agree that that was not something that should have occurred.
Okay. And you still deal with these highly litigious cases to this day, is that correct?
Yes.
And since you've been on probation, have you ever assumed any dual roles as a parent coordinator and a therapist, or in any professional capacity in dual roles in any case that you've had?
No, I'm crystal clear.
Okay. So what kind of safeguard, well, you did explain some of the safeguards that you put in place. Where, especially with the informed consent, you say you send the form that you have to the attorneys first, and then you give them to the patients as well, is that correct?
That is correct, and then we verbally go through them just to make sure they understood everything and, weren't too nervous perhaps to really take it in.
Okay. And then you also keep a paper file, a scanned file, and you have a Carbonite system, so 3 different ways that you document the informed consent.
Yes, I don't think I could lose one.
Okay. When did you institute that policy?
When this all came to pass.
Okay. And you did have a practice monitor for 1 year while you were on probation, is that correct?
I did.
And then I think you had asked the board to modify your probation at the 1 year mark to terminate the monitor?
Correct.
Okay. And that was granted by the board?
It was.
So if you can explain to the board why you think they should grant your petition?
I believe that I've taken everything very seriously, that I've made all of the changes that caused the series of events that occurred, and I've continued to engage in the highest litigation part of psychology and have not had any issues.
Your Honor, I have no further questions.
Thank you. I'll then ask if the board members have any questions, and please state your name before asking your question so the court reporter can get that down. Thank you. Yep.
No questions at this time.
Thank you.
I do. Jacqueline Horn. Dr. Love. Couple questions for you. What do you think happened that you weren't aware or as aware as you are now of issues like multiple relationships, about precautions that needed to occur with informed consent, about confidentiality? What happened that, because you had been practicing in this area for a long time?
Correct. I would say in this case it was extremely difficult. The court order was not clear from the beginning, and I'm very clear that that's my responsibility to have that clarified and to send something to the attorneys and let them know that I'm not completely clear on my role. I think I was lulled into a false sense of things are going so well for them. It's all working out so great. It's fine to be working together as a family. And I lost sight of this family had been in court since the children were 1 year old, and they continue to be in court. And that just because things were going well doesn't mean that I can bend my ethical obligations and my responsibility. So I think that was part of the problem. I'm trying to think your other informed consent.
Just the areas that that you've been disciplined for.
Right. So the multiple roles, I think, when this started in 2010, it wasn't clear to me. When it came out in 2012, I thought things were going so well and we were going to wind down, and probably one of the biggest mistakes of my life, because when that came out, it was in January of 2012. That was the day I should have said, holy moly, I need to meet with you guys. We need to talk about this. I need to terminate, performing this particular role. You need to go back, get the girls back, and whatever, or refer them to other people. But instead of thinking this case is okay, some kind of grandfather clause in my own head, it wasn't.
So what do you think, I understand that you've put different procedures in place, but you're also talking about something that was going on internally for you. So what kind of precautions or changes would you make now if you get caught up in a family or something like this? It looks like it's going okay, the same kinds of things. What kinds of things would you or could you do now?
Well, one of the things is meeting with my practice monitor. I don't have to pay her anymore, and it's much less. She doesn't come in and get the key to my file cabinet. It's not as anxiety-provoking and contentious, but we've continued to meet because I actually found it very helpful, and I've enjoyed sharing, details about certain situations and not having to go anywhere. We have this set meeting and we meet, and sometimes I have a list on my phone of things I want to talk about, and she knows everything that happened to me. She's read everything that I've done. So in a sense, she's very informed on where I might make an error, and she has no hesitation of speaking up and telling me that I might go into a bad area if I go that way, or what I should do or shouldn't do. She's very practiced, and she's been very kind and helpful.
So do y'all meet still as regularly as you had met when she was still your practice monitor before?
No, we meet once a month.
Okay. Okay. Thanks so much.
Thank you.
Good morning, Dr. Love.
Good morning.
Alita Bernal, Alita Bernal. I had just one question, and it sounds like you've gone to extremes on the informed consent. But I did hear you say that as a Latina in this community, just out of curiosity, do you also have Spanish-speaking patients?
Multicultural, I do not perform custody evaluations in Spanish. I do not feel competent.
Okay. I was going to ask if they were in Spanish as well, but thank you.
Thank you, sir.
Good morning, Dr. Love. I just want to make sure it was still morning. At several points in your petition, you make mention of the AFCC guidelines. Why aren't you talking about the APA ethics code?
I believe that was pointed out, that I was referring to the APA ethics code.
So each time you talked about the AFCC guidelines, you were talking about the APA ethics code?
Correct.
Okay. You've pinpointed 2012 as a point where things changed in the guidelines, is that correct? Or the ethics code?
The standards.
Weren't multiple relationships prohibited before 2012?
Multiple relationships weren't inherently forbidden, but if they could lead to something that would jeopardize my effectiveness, objectivity, it's something that should not have been done.
And also if there's a risk of harm to the patients, right?
Oh, clearly.
Okay. What were your multiple relationships? Could you identify for me each of the multiple relationships?
Sure. One of the things that I was appointed for was a parenting coordinator. There was also a / on the court order saying mediator. So those roles are not interchangeable. So from the start, what I would do today is write the attorneys back and say that I needed clear orders and I needed a decision as to whether they would like me to be a confidential mediator, a reporting mediator, or a parent coordinator.
So they would have to choose between one of those roles.
Absolutely. And just saying mediator isn't even enough.
What other multiple relationships did you have?
So when the children were, so the attorneys had called me after the order was received and said, there's also a CPS safety plan in place. We want you to oversee it, and we want you to make sure that the children are safe. Right there, I should have said, we need a therapist for that. We need somebody else to do that. I can't be the parent coordinator, the mediator, and oversee a CPS safety plan and make sure, because that involves meeting with the children regularly to make sure they're safe.
So that's where they refer to you as being the children's therapist, correct?
I believe so.
Okay. And you were a therapist to two siblings, not one sibling or the other.
That is correct.
Do you consider that a multiple relationship?
It certainly could be.
Yeah, it is actually a multiple relationship,
Correct.
I think. Whether it's permissible or not is dependent on applying the standard.
Whether or not it's a problem, right, is the question.
You also prepared letters under penalty of perjury, and I think you said somewhere in your paperwork that you anticipated that the attorneys might want to file these things with the court.
Correct. I had written something like 26 letters that they had requested over the course of years.
So were you also acting as a custodial evaluator?
No.
What was the nature of the letters?
In parent coordinating, I follow up within 48 hours in writing the agreements that were made by the parents or further things that need to be explored. So it's kind of a documentation of our work together.
Okay. You said you no longer sign your letters under penalty of perjury, correct?
That is correct.
Why?
Because in this case, what ended up happening was an attorney filed it with the court and it was used, and it was court ready, let's say. And at this point, what I've learned from my attorney through the process is to not do that. And if someone wants it admitted to court, I have control over it because I would know and be able to put it under penalty of perjury, and I'd have permission.
And it would be just as to what subject?
Whatever specific subject I would be addressing.
Okay. So was there any point in time while you were going through this before you saw the APA Ethics Code or AFCC guidelines? Still not clear to me, but whatever it is that you saw, was there any point prior to then that it occurred to you that you were taking on too many roles?
I would say when I saw parent coordinator mediator, the slash, that it concerned me that my role was not defined. But relying on the attorney phone call was not sufficient for clarification of that. That'll never happen again. I want it in writing before anybody gets through my door.
And whatever the attorney tells you, you still have to determine whether you meet the ethics guidelines or the ethics code.
Oh, absolutely, even the court orders. Sometimes judges send us orders that don't meet the guidelines, and it's
Right.
my responsibility to request clarification or change.
Okay. Did you have informed consent for this, for all these different roles?
I had the original parent coordination paperwork, and then in the file, I have informed consent for therapy, but it's not signed by anybody.
Oh, so there was no signed copies of any of the informed consents?
The original, but not the therapy portion for the children
So
when I
just
took
for the
that on.
parental coordination.
Right.
But you didn't have a signed written consent to treat the children?
That's right. It's just in there as the paperwork that I hand to people.
And you didn't have a signed written consent to do mediation?
That would be correct.
Okay. Because I was a little confused in reading your petition. It seemed like you were saying I wasn't able to produce a signed written consent that would be appropriate. And I've changed all these record-keeping procedures to make sure that I have backups on all my files. I keep a paper file and I keep a carbonite file, I guess. But it's not a question of you having had it but just not being able to find it. It's a question of you never having gotten these additional consents.
It's a question of not getting the signatures on the additional consent. There's a informed consent for therapy in the AG's file, but I don't have one with a signature on it, so I understand that that's not very meaningful.
That doesn't constitute informed consent, does it?
Correct.
Okay. I also noticed that you were describing who was harmed by your actions. And you said in the parent, that in going outside your role of a parenting coordinator, it was a polarizing situation for the parents. And it further polarized the litigation.
I think that's probably the thing I feel the most badly, the saddest about, is that this is a very disturbed family system, and my actions only made it worse in the end, when my intention, obviously, for going into this field is to help and to reduce conflict and to let children have normal and happy lives when their parents are terminating their marriage. And instead, my actions contributed them to becoming even more polarized than they were before.
Who else besides the parents were hurt?
Well, potentially the children, because they were extremely attached and they needed to have their care transferred within, I think it was a 1-month period. And I know that was really difficult for them.
So effectively, because of assuming all these roles, you had to abandon your role as the children's therapist, right?
The judge assigned another therapist, yes.
Correct, but it was as a result of this whole kerfuffle.
Right.
Okay. Okay. What's your relationship to Robert Simon?
He is a colleague in San Diego that also performs custody evaluations.
Do you refer back and forth to each other?
I have.
And as to Ms. Dr. Altes, I think that's the correct pronunciation of the name. Maybe I'm mispronouncing, Altes.
No, I think that's correct.
Is she also a colleague that you refer back and forth with?
Yes, she also is a custody evaluator.
Okay. There was also concern about confidentiality. So that was the third kind of the leg of the stool, so to speak. And not getting releases to provide confidential information. How do you understand the failure to get releases in the context of that situation that you were in? Who did you need to get releases from, and for who?
Well, that would be the parents to release the information to the attorneys, which is, I did have consent to do that. The problem was one of the attorneys filed it with the court, which the other parent did not want to occur. So I need to protect my information, my letters, so that that can't happen.
So how would your procedures change in that situation?
Well, I do not sign under penalty of perjury, so that it just can't happen. I mean,
Right.
or if it is submitted to the court, the judge won't admit it as evidence because it's not under perjury.
Right. But what do you do in terms of getting consents when there's two people involved and you're reporting, in terms of releases for confidentiality?
Well, those are in my original paperwork with the attorneys when people come through the door now. And if for some reason that wasn't necessary or they didn't have attorneys, they sign releases prior to letters going out.
So as part of the informed consent package, they're signing releases for you to be able to release information to the court and to the attorneys?
Correct.
Okay. Did you have releases for the children? In other words, you're treating them as a therapist, right?
Correct.
Did you need to get releases from anyone to release any of their information?
Well, the parents, yes.
Right. So what's your procedure?
Well, the procedure is having the releases. They're readily available on my desk now, leaning over and saying, yes, I understand that's a court order. I need to get this report in. I need you to sign it. But quite frankly, it's usually signed in the original paperwork, and we've discussed that understanding.
So in your informed consent for working with children in the context of a high conflict divorce, do you get a release up front from the parents?
I do, and then I always talk to the children at an age-appropriate level, whether they're 5 or 15, and it differs, the amount of information I give them. More important when they're adolescents so that they really understand the nuances.
Right. Right. Has your procedure changed as to whether you're requesting signatures on those releases from both parents?
I always intended to do that, and I continue to get releases from both parents, unless there's there's one caveat, if only one parent has legal custody. But even then, I'm probably going to be talking to the other parent.
It's probably better practice to get that second consent anyway?
Correct.
Okay. All right. Thank you.
Thank you, sir.
Good morning, Dr. Love.
Good morning.
Michael Erickson. I have a couple of questions. Following up on Dr. Phillips' questions about informed consent, could you explain to us when there's two parents and you're seeing them both, and maybe there's some contentious issues between them, and one of their attorneys asks for a letter to go to the court, how do you deal with a situation where maybe the other parent doesn't want his information submitted to the court, and you have releases already, or you get new releases for every, how would that work?
In the beginning, it's all laid out ahead of time what the procedure will be. Some people, I do the most parent coordination in San Diego County, so I have many, many cases. Some people don't want their attorneys to have the information, so from the onset, they don't want to be charged. They want to get out of the court system. So from the onset, we discuss whether it's going to be email, Our Family Wizard, U.S. mail, how they're going to get the write-up from the session, and be given the opportunity to review it and make changes. So that's what happens for some cases, and we discuss it right up front. Some need it to go to their attorneys, and we all agree upon that and discuss it in the very first session, and I have the releases signed. Some need them to be filed with the court, and they both agree to that, and the attorneys agree to that, so I get the release of information for that. So every situation is a little bit different, but as long as it's discussed and delineated ahead of time, it has not been a problem.
Okay. And I am still curious about the informed consent. At one point, it sounds like the forms weren't available. At another point, it sounds like you had forgotten to ask them to be signed, or maybe they were left in the chart and never presented to the parents, or maybe the forms were not adequate and new forms have been created, or maybe they've been lost and now you don't lose. I would like to understand that more clearly, if you would explain that, if you could.
Sure. I didn't want to get into defending myself or saying anything like that because I've accepted responsibility and have moved forward, but I believed that I had a signed consent, informed consent from each parent, which is what I normally do, in the file. And when I went to produce that, I had the informed consent that was signed by neither parent. So the copy, so I have them sign it, but then I give them a copy because I figure people would like to review it at home and when they're not in front of me.
Yeah.
So I believed that I had 2 informed consents for therapy signed by each parent. In the file, there was only an informed consent that was not signed by anybody. So I wish I could tell you exactly what happened, if they went home with the one that was signed, I don't know.
Okay.
But I do know that if it's in the file, the other thing is this file was copied over 2 times by a copy service. And I will tell you another thing that we have done is I used to just put them in a room with their copier and give them the file, never allow them to take it out of the office. But now I have an assistant that sits there and watches because I have concerns in these cases that perhaps something gets removed, misplaced, or lost. But I'm not trying to say that it's the copy service's fault. I'm not trying to say that I am taking full responsibility.
Thank you. That helps clear up what had been a little confusing to me. A hypothetical situation, if you were teaching a seminar to early career psychologists that were getting into family custody, mediation, and so forth. Do you think you could use your case, this case we're talking about that is the basis for discipline, as a learning moment, as a case that you could use to teach people that are wanting to learn about this what can go wrong? And if so, could you give us a quick outline of the mistakes that happened from start to finish in this particular family? The mistakes you made from start to finish.
That's interesting because I'm actually working on something like that now. But I would never use this family as an example in any way. I've been very concerned about their confidentiality in the entire process. So even without a name, I don't think it's appropriate to cite anything personal. However, having really strong sections on being able to have a clear court order and it being your responsibility, having real clear sections on multiple relationships, and even though there are times when it's acceptable when you're working in child custody, you just don't do it. You've got to protect yourself and you've got to protect the client. So, and in terms of informed consent, I've actually am giving copies of my new paperwork, which is, I think, really good, as an example, and citing that sometimes, I think something that is helpful to know is that sometimes it changes for whatever reason, and you might discover a fact in a case that you need to emphasize something, so that informed consent is something that is always kind of changing, and they need to be aware of it.
Good. And maybe a final question is, what have you learned to look for in terms of opportunity to get consultation when things aren't going too well? I know that when Dr. Horn was asking a few questions, you mentioned, I think it was January 2012, things looked wonderful. I'm not sure what had happened then, but where were the places along the way in time where maybe it would have been, in hindsight, wise to get consultation from a colleague around who it looks like multiple roles are developing, this could be a boundary issue, what do you think, that sort of thing? Can you identify some of that?
I think that's interesting in the sense that I would probably call it a boundary issue when I receive letters from attorneys saying you're doing such a great job, you're a breath of fresh air, thank God you're here, this family's doing so well. I would say that I took that to heart too much, and that probably caused me to let my guard down a little bit, and I can guarantee you that'll never happen again. And I think that's one of the things, interestingly, that my former practice monitor and I talk about, is getting lulled into a false sense of, I don't know, it's almost like a narcissistic positive, right? It just feels so good to be told you're doing such a great job and the family's functioning so well and we're so happy with you. And I have letters like that from the attorneys. So that I'm going to be vigilant for the rest of my career.
Good, thank you. No further questions at this time.
Thank you. Doctor? Hi, Dr. Cheryl Kasuga here. Dr. Love, I just have a question with regards confidentiality still. I feel like you've reflected a lot on this particular case and the mistakes that have occurred, and you also made some changes in your practice, as well as did a lot of educating yourself. But in terms of general safeguards for confidentiality, is there any change in your ethical decision-making process to make sure to safeguard confidentiality of clients in the future for other cases?
Well, I think the most important thing that I've done is stop signing letters under penalty of perjury, so that there aren't any misunderstandings, and the letter that goes to an attorney doesn't get misused. Even if I have the permission to send it to the attorney, I have a responsibility to safeguard that letter if I do not have permission to send it to the court. So that's one thing. The other is that before they walk through the door, the process is established as to what the expectations are with confidentiality, and then their attorneys are aware of it, they get to be aware of it, and then we discuss it. So there really isn't an opportunity for any confusion or for something to slip through the cracks.
So, so right now you're actively discussing things every step of the way with the clients and the attorneys. That way you can clarify what can be released and what releases are needed in order for some information to be sent.
Well, right, and I think the most important part is that we're discussing it, that there's a clear understanding, not just a signature on a form, but, and I can tell you that there have been many conflicts over the last year and a half of people that have different understandings of where it's going to go, and we work it out before we start. And it's that I think has probably made a big difference.
Okay, so mostly the setup, so you can lay the groundwork from the start with regards releases and confidentiality. But in terms of your ethical decision making, has there been any changes to make sure that confidentiality issues that don't occur in the future?
Well, absolutely. I'm taking it very seriously and trying to safeguard up front, and then also understand that changes occur, and I can't just have a secretary send a release to somebody, that's something we need to talk about if it changes. So I think talking more to the clients and making sure that we're all on the same page is probably really good for them and obviously really good for me.
Okay, thank you. Thank you. Do any other board members have any additional questions? Seeing none, any additional cross-examination?
I'm sorry, I have one quick question, Dr. Love. You've got 6 months left, is that correct?
Correct.
Okay. And I know you've met your requirements and whatnot, and so why would you want this 6-month early termination, just out of curiosity?
That's a fair question. I'm pretty much ripped apart on a weekly basis in court at this point because of the probation, and it is pretty humiliating and difficult to deal with. It gets posted on the internet, about once a week, and on like different health grades and forms and things like that. So to do my job, it is actually a distraction from me being able to do the best work that I can, because people get caught up on it and they want to question me on the stand as to my ethics and my commitment to working with families and children and at the highest ethical standard. So I'd like to move forward and get back to doing my job without the distraction being brought up by attorneys on the internet.
Thank you. Anything additional?
One other question. You're still always going to have been somebody that was on probation, right?
I am.
And do you think the attorneys are going to stop because you got off probation?
I think it will certainly bode better than being on probation.
Okay, thanks.
Thank you. Any additional cross-exam, counsel?
No, Your Honor.
Thank you. Doctor, anything additional you wish to tell the board?
No, I don't think so. I think you understand. I feel I've gone to monumental efforts to change things so that I never hurt a family in any way or end up in this situation again.
Thank you. Ma'am, do you wish to make a closing argument?
Just briefly, Judge. So just wanted to remind the board that the petitioner has the burden of showing by clear and convincing evidence that she has rehabilitated herself. and is entitled to have her license fully restored. And we do have guidance through Title 16 of the California Code of Regulations. It's Section 1395, which contains the grounds for rehabilitation that the board may consider, and I just want to briefly talk about those. The first is the nature and severity of the acts under consideration as grounds for discipline, and I think the board fully understands that these are serious allegations. These are serious ethical violations, and I think the board has had the opportunity to ask Dr. Love about more about that. The time that has elapsed since the commission of the acts, as I said in my opening statement, the treatment in this case was from 2010 to 2014, so it's over 4 years ago at this point. And the extent to which the applicant or the petitioner has complied with any terms of probation lawfully imposed. She has been on probation for almost 3/4, or for 3/4 of the time that she was originally put on probation. There's no evidence of any violations of probation, and she has complied to a T. And then you've heard the rehabilitation that she's explained to you all in terms of how she's changed her practice and what policies she's changed and how she deals with ethical issues at this point. So at this point, I just want to inform the board of the law, and then I'll submit on that.
Thank you. Ma'am, your closing argument, do you wish to make one?
No, thank you.
Thank you. With that, the matter is submitted, and I thank you both for your presentation. We're off the record.
Thank you.
And for the court reporter, Altes was ALTES. You're welcome.
Why don't we take a 10-minute break? We may come back and address other items on the agenda since the next hearing is not set to start until, I believe, 1 p.m., 1:30. If all the parties are present and they want to proceed with it, we can do that as well. So we'll use this 10 minutes to find out. Purely for the purpose of going into closed session. So that people have an idea of the schedule now. We're going to be deliberating about a variety of different things. And I would expect that we're going to be back here a little bit before 1:30 so that there's sufficient time for people to set up for the 1:30 hearing. So you'll have a nice long lunch break if you're not going to be here in closed session. So I would ask people to clear the room. Thank you.
Okay, on the record, in the matter of the petition for early termination filed by Thaddeus Camlin, Psi D, OAH case number 2018-100361, agency number 600-2018-000469. My name is Mary Agnes Matazuski. I'm the administrative law judge assigned to hear this matter on November 15, 2018 in San Diego. May I have appearance, please, beginning with the agency representative.
Good afternoon, Your Honor. Deputy Attorney General Leanna Shields on behalf of the AG's office.
Good afternoon, sir.
Thaddeus Camlin.
And sir, since you represent yourself, I'll just explain to you briefly, the issue for the board is public protection, and they're looking for rehabilitation evidence. This is not an opportunity to rehash the discipline that was imposed, but to give your testimony regarding rehabilitation, mitigation, and explanation of what occurred and why the board won't worry about this ever happening again that led to the discipline. We've talked off the record that the Attorney General will give a brief summation, introduce evidence, and then it'll be your turn to testify. She'll then cross-examine you, and then the board members can all ask you questions. If at any time you don't understand anything, if you have any questions, please let me know, because I want you to fully understand everything here this afternoon, okay? Any questions, sir?
No questions.
Thank you. Counselor?
Thank you. We are here on a petition for early termination of probation. The grounds for probation stemmed from petitioner's criminal convictions. 2 convictions related to possession of drug paraphernalia, and 1 conviction for reckless driving, which resulted from an arrest for driving under the influence of alcohol. Briefly, on March 15, 2011, petitioner pled guilty to and was convicted of attempted possession of drug paraphernalia. This was a misdemeanor in Arizona. Prior to that, on January 13, 2006, petitioner was arrested for driving while under the influence of alcohol. According to the arrest reports for this incident, petitioner admits having 5 drinks prior to driving, specifically 4 beers and a shot. His BAC was determined to be 0.14% and 0.15% an hour after driving. During a search incident to arrest, the officers located a baggie of marijuana and a pipe in his pant pocket. As a result of this arrest, he pled guilty to reckless driving, a reduced charge from DUI, and possession of drug paraphernalia, both misdemeanors in the state of Washington. In April 20, 2015, petitioner submitted an application for registration as a psychological assistant with the Board of Psychology in California. This application was denied on June 29, 2015, and on April 12, 2016, a registration was granted with an agreement to 4 years probation. This was effective on May 12, 2016. On May 12, 2018, he filed his petition for early termination of probation exactly 2 years from when his probation commenced. It has now been approximately 2.5 years since the effective date of the board's decision. Before the court is a binder of the Attorney General's proposed exhibits. Petitioner has also been provided a copy of the exhibits prior to today's hearing. I'd like to go through each one and offer them into evidence at this time.
Thank you.
Exhibit 1 is the notice of hearing. It's based AGO 1A through 2. Exhibit 2 is the Board of Psychology guidelines for oral argument. Exhibit 3 is a certificate of licensure. Exhibit 4 is the certified final decision and order of the board in case number 600, 2015, 000622. Exhibit 5 is the redacted petition of his petition for early termination in case number 600, 2018, 000469. I have the originals if you need an unredacted copy to present to the board. Exhibit 6 is a certified copy of the Board of Psychology probation file for petitioner. Exhibit 7 is the Board of Psychology probation report. And then just provided this week, we have Exhibit 8. It should be a loose leaf, additional documents provided by the petitioner. It's Bates labeled AGO 214 through 218, and it includes 2 certificates of completion, one of SMART recovery, and one for the completion of supervision of craft, a letter from his treating psychologist, Dr. DeSoto, a letter from Dr. Horvath, his practice monitor, and an Excel spreadsheet with I believe it's an activity log that he was keeping. I'd like to move these into evidence at this time, 1 through 7. If he would like to move 8 into evidence, that's his decision at his time.
So I'll start with you, sir. Any objection to my receiving exhibits 1 through 7?
No objection.
Okay, exhibits 1 through 7 will be received. And sir, are you offering exhibit 8, the additional documents?
Yes.
Any objection to my receiving exhibit 8 as administrative hearsay?
No objection, Your Honor.
Exhibit 8 will be so received. And sir, just so you know, administrative hearsay are out-of-court statements or documents from individuals which will supplement or explain your petition and the evidence that you give here today. With that in mind, sir, can you raise your right hand? Do you solemnly swear the testimony given in this matter is the truth, the whole truth, and the penalty of perjury of the laws of the state of California?
I do.
Thank you. Can you state your full name, please, and spell your last name for the record?
Thaddeus James Camlin, C-A-M-L-I-N.
Thank you, sir. And you can tell the board whatever it is you want them to know.
I want to thank Your Honor, Deputy Attorney Shields, and the board for taking the time to hear my case. To accurately and thoroughly convey the evidence in my case, I respectfully anticipate my opening statement to take approximately 15 minutes. I know you all have more pressing matters to attend to, and your time and consideration is very much appreciated. This hearing intends to focus on events since the onset of probation, so my opening statement will primarily focus on the occurrences since May 12, 2016. It is my contention that clear and convincing evidence of rehabilitation exists in both the subjective evidence of a mature, measured state of mind that reflects a sincere appreciation for the gravity of my misconduct, and in the state of objective facts that I believe are so clear as to leave no substantial doubt about my ability to practice safely without probation.
Sir, can I just stop you there once again? You're saying it's your opening statement, but if you're under oath, it's evidence and testimony that you're given. Opening statement is evidence that it's not evidence, so we can't consider it. So are you offering this as evidence?
Yes.
Okay, then thank you. Just so the board's aware that it's evidence of what he's saying.
The evidence of my rehabilitation needs to be sufficiently strong to command the unhesitating assent of every reasonable mind, and I contend that it is. I'll begin with the subjective component of evidence, my state of mind. The first thing I'd like to discuss in regard to my state of mind is my petition. I look back over this petition today and see a few things that I would like to clarify. On AGO 0038, item number 5, while I believe it to be true that actions of mine before practicing did not harm current patients, I want to clarify that I fully appreciate that being arrested for DUI and possession of a substance while practicing would cause harm to patients. I believe that as psychologists, part of our work is to lead by example. Some patients would likely lose trust in their psychologist if their psychologist put the lives of others at risk by operating a motor vehicle while under the influence. A loss of trust would damage rapport, and rapport is consistently shown to be a crucial factor in successful treatment. Additionally, a restricted license results in being kicked off insurance panels, which could affect the ability of patients to afford treatment, and even if referrals were handled ethically and professionally, such an unexpected change in the course of therapy would be harmful to some. Secondly, item number 6 on AGO 0038 asks how I would handle the situation that led to my discipline were it to happen today. In an attempt to convey my confidence that events which led to my discipline will not occur again, I feel I did not adequately answer the question. While I am confident that I will not experience legal issues of any kind for the rest of my life, should a situation arise in the future similar to what led to my discipline, I would immediately seek consultation, suspend practice in a manner that considered patient well-being as paramount, undergo treatment, and not return to practice until cleared to do so by external parties such as an evaluator or the Board of Psychology. The next thing I'd like to discuss in regards to my state of mind is the changes I've experienced throughout the course of probation. My initial reaction to my psych assistant application being denied was one of fear and anger, and I was admittedly skeptical about the usefulness of probation at the onset. My attitude and state of mind shifted throughout probation from one of rejection to one of frustrated resignation, to one of openness and gratitude. I was determined to cultivate an attitude of meaning through the adversity, and I challenged myself to learn and grow through the process rather than to wait it out and begrudgingly check the boxes. While I did briefly entertain the idea of abandoning licensure altogether, I recognize that walking away from my goal to be a psychologist at such a late stage in the process would be a betrayal of myself, my values, and my efforts. Consequently, I've taken the probation process seriously and gained a greater awareness of myself. My current state of mind reflects true change, as it is now one of appreciation for the board's flexibility and willingness to give me a chance, and deep gratitude for the privilege to practice. It's an old cliche that we never know what we've got till it's gone, but I can say with certainty that thanks to my experience on probation, I will never take the privilege to practice psychology for granted. Central to my shift in attitude from frustration to gratitude was the ultimate truth derived from my Jungian analysis that the only constant in my life is myself. I could have maintained an externalized focus on aspects of probation that I felt were unfair, but engaged Jungian work does not allow for one to look outside oneself for very long. The truth of my probation is that my own misconduct created it. Because it was my own misconduct that created my probation, the experience of probation resulted in another close examination of my past behaviors through the lens of a different, more mature person. While I can confidently say I've taken full responsibility for my actions and truly appreciate why they were wrong, the view of my actions a decade removed from them is different than in the years immediately following them. While I know the focus of this hearing is on the events during probation, and it is not intended to rehash the events that led to my discipline, I find it necessary to briefly acknowledge the events that led to probation to paint an accurate picture of my current state of mind. Nearly 13 years ago, on the 13th day of 2006, I drove with a blood alcohol level of 0.15, almost twice the legal limit. This was the worst mistake of my life, and I am grateful that my arrest is the worst that came of such a terrible decision. My actions were a gross error in judgment. I binge drank and operated a motor vehicle, something I was careful not to do prior to my DUI and something I have never done since. My experience after my DUI was a motivating one. While I fully acknowledged that I binge drank and operated a vehicle, some of the experiences I went through in the aftermath of my arrest centered around convincing me to admit that I was an alcoholic. I did occasionally binge drink in my teen years and early college years, but I did not believe I was an alcoholic. I did not believe everyone who got a DUI was an alcoholic, and I became determined to learn more. In the 13 years since my DUI, I've learned quite a lot about substance use, how it is treated, and the current research in the field. As a psychologist, I now specialize in treating substance use. I can say with confidence that while I did experience problems related to alcohol and cannabis, I am not an addict or an alcoholic. Furthermore, as psychologists, we generally advocate for person-first language. It is widely preferred to refer to someone with a diagnosis of schizophrenia as a person with schizophrenia, not a schizophrenic. However, the common decency of person-first language that has become a standard of care in all other areas of mental health is largely absent in the realm of substance use disorders. Saying that a person drinks problematically is rare, and calling someone an addict or an alcoholic is rarely given a second thought. Fortunately, the DSM-5 does not fall into this error. The double standard of not applying person-first language in the treatment of substance use reflects the deep need to improve the treatment of substance use. Raising the standard of care in the treatment of substance use is a constant source of meaning, passion, and inspiration to me. Inspired by Viktor Frankl, I seek to turn my own struggles into something that helps and inspires others. During my probation, I also revisited the fact that my past misconduct was not a single incident. I was arrested twice across the span of 4 years. My second arrest suggests a lack of appreciation for the severity of my misconduct during my first arrest. I believe that it is important to note that while subsequent violations do reflect a lack of learning, the severity of my violations decreased. After my first violation in 2006, I took my drinking mistake incredibly seriously and never binge drank or operated a vehicle under the influence again. However, I did continue to use cannabis. While I still believe that possession of cannabis is not a crime, and recent changes in laws have indeed been validating for me in that regard, I fully recognize that a second arrest for possession of cannabis in 2010 suggests a disregard for laws pertaining to the use of illegal substances. I also fully acknowledge that a disregard for laws in general, and for laws about the use of illegal substances in particular, reflects poorly on the profession of psychology. Just because my arrests occurred in decreasing severity does not mean that I don't recognize that my actions that led to my second arrest reflect poor judgment. After my 2010 arrest, I never used cannabis again. To summarize my state of mind, probation afforded me the opportunity to look back on the mistakes in my past from a distant vantage point, see them in the fresh light of new learning, and clarify my own understanding of myself through the benefit of focused, depth-oriented psychotherapy. Probation offered me the opportunity to grow in my understanding of my own intrapersonal dynamics, to benefit from the lived experience of conforming to authority, even if I may disagree, and practice the strategy of achieving personal growth through intentionally going against my own grain. I contemplated walking away from licensure. I challenged myself to complete probation with an open mind and an attitude aimed at personal growth through adversity. I stayed the course, and I am a better person and a better psychologist because of my experience on probation. Moving to the objective evidence in my case, I argue that the objective state of facts command the unhesitating assent of every reasonable mind. For over 800 days of probation, I never missed a check-in for drug testing. I provided exclusively negative samples for all unapproved substances on 72 different drug tests. I submitted every quarterly report on time. I completed the ethics course on time. I completed the psych eval on time. You can see on AGO 0210 through 0213 that my probation report is about as clean as a probation report can be. While checking the boxes of probation is only part of the process, my probation record offers clear and convincing evidence that I have taken this process seriously, that I have no issues with substances, and that I'm safe to practice without probation. The next objective fact I'd like to discuss is my psych eval by Dr. Devorah Lockton, AGO 0167 through 0170. Dr. Lockton's report provides further objective evidence to support my assertion that I'm safe to practice without probation. Dr. Lockton states on AGO 0170 that I do not merit a DSM-5 diagnosis, that I've been evaluated several times in the past and was not found to have an ongoing substance use problem, and that she did not find that I had a substance use problem at the time of her evaluation. Dr. Lockton also found on AGO 0169 that I take responsibility for the decisions that led to my arrest and that I fully acknowledge that I made bad decisions. A psychological evaluation by a board-approved evaluator finding that I take full responsibility for my mistakes and that I do not and never have had an ongoing substance use problem is compelling, clear, and convincingly in support of an early termination of probation. Next, I call attention to my practice monitoring. During probation, my practice monitor noted on each and every practice monitor form that my practice was at standard and that no corrective action was needed. It's on AGO 0174 through 0184. On the practice monitor information sheet in my petition, AGO 0041, my practice monitor noted that my practice was typically much higher than the standard of care throughout the course of monitoring. In a letter from my practice monitor, AGO 0217, he states that my practice is beyond standard, that there appears to be no further benefit from keeping me on a probationary status, and that ending my probation status would be an appropriate acknowledgement of my fulfillment of the terms of probation and my excellence in our field. A practice monitor supporting the early termination of probation and reporting that my practice was at the standard of care, never below it, and typically much higher than standard for over 2.5 years is an objective fact that shows consistent, safe practice over time. Next, I'd like to call attention to my treating psychologist. My treating psychologist throughout probation noted in all 9 quarterly reports that I was competent to practice, AGO 0127 through 0139. Her reports describe my engagement in treatment as motivated, AGO 0138. She says that I was consistent and steady in my dedication, AGO 0137. Diligent, AGO 0136. That I've become increasingly trusting of my own inner authority, and that my self-exploratory process has been impressive, AGO 0134. That I continue to progress in my deeper archetypal delving into complex issues, AGO 0133. That my struggle and attainment has been consistent and substantial, AGO 0129. That my therapy resulted in a shift in outlook on self and life, AGO 0127. And that termination of probation should be considered by the board, AGO 0127 through 0129. On the therapy information sheet, AGO 0040, my treating psychologist noted that she recommends termination of probation with no restrictions required. The objective fact that my treating psychologist consistently assessed me to be competent to practice, frequently described my motivated, engaged progress in therapy, and recommended that probation be terminated, provides clear and convincing evidence that I'm safe to practice without probation. As part of my therapy, I tracked hours of weekly engagement in meaningful activities, AGO 0218. My engagement in balanced lifestyle activities increased throughout probation, and the increase is reflected in the data on the spreadsheet. I play guitar almost every night. I mountain bike and hike almost every weekend. I read multiple hours every week. I make and edit home movies. I write. I live a rich, fulfilling, and balanced life. The increasing engagement in meaningful activities reflected in the data submitted is objective evidence of ongoing personal development through improved lifestyle balance achieved during the probation period. Further objective facts include my completed training as a certified smart recovery facilitator, my certification in community reinforcement and family training, or CRAFT, publishing an article version of my dissertation on opioid use disorders. An article version of my dissertation on opioid use disorders in a peer-reviewed journal. Attending CE events on substance use, passing the EPPP, passing the CAPLE, and earning my license as a psychologist while on probation. The certifications earned in the publishing of my dissertation offer objective evidence of my efforts to stay current in the field of substance use. Passing the EPPP, CAPLE, and earning my license as a psychologist provide objective evidence of mastery over clinical psychological concepts, especially in the realm of ethical and legal practice. Staying current in the field and earning my license as a psychologist offers further objective evidence in support of my growth during probation and my safety to practice without further probation. Lastly, in regard to the objective state of facts, the time elapsed since legal problems offers clear evidence of rehabilitation. There's no doubt that my misconduct was severe. But but it has been just under 13 years since my most severe offense, and just under 9 years since my last offense. The time since my last offense is more than double the time between offenses. My time since last offense, about 1 year shy of a decade, demonstrates sustained conduct over an extended period of time, which has been established in case law as a critical objective evidence of rehabilitation. To summarize, my overarching feeling today is one of gratitude. I am grateful to the board for giving me a chance, and I will succeed regardless of the outcome today. I contend that my state of mind reflects insight into the misconduct of my past and a mature, measured appreciation of why it was wrong. I contend that the objective state of facts is so clear as to leave no substantial doubt of my safety to practice without probation and commands the unhesitating assent of every reasonable mind. Thus, the burden of proof has been met. The lessons learned from my mistakes are emblazoned in my awareness and are a daily inspiration for my work. I ask for early termination of probation, not because I seek relief from the financial costs and the professional limitations, although I won't miss those a whole lot. I ask for early termination because there is clear and convincing evidence of my rehabilitation, and as a humble request for acknowledgement of my efforts and as an affirmation of my success. Thank you.
Thank you, sir. Cross-exam?
Thank you. Dr. Camlin, I'm going to talk to you first about the Arizona conviction. You were arrested in 2010, is that right?
Correct.
And then the conviction didn't occur until 2011?
Sounds right.
So about that time you were approximately 29, 30 years old?
Sounds right.
Okay. Were you living in San Diego at the time of the offense?
Yes.
And during this time period, you said that you were smoking marijuana several times a week, is that right?
While I was living in San Diego prior to the arrest, yes.
Approximately how many times a week would you say you were smoking marijuana?
2 to 4.
And the reason you all were transporting marijuana over to Arizona is because your girlfriend's mom had asked for some, is that correct?
Correct.
And then you were stopped at the border by a K-9 unit, right?
Correct.
Were you and your girlfriend both cited, or was it just you?
Both of us were cited.
And you understand that you were cited, it wasn't an infraction but a misdemeanor arrest, correct?
Correct.
Do you remember talking to Dr. Lockton about this during your psychological evaluation on June 25th, 2016?
Yes.
Were you truthful during that evaluation?
Yes.
Do you recall informing her that you began using marijuana in the 8th grade?
Yes.
Was that true?
Yes.
So you were approximately age 13 when you were using marijuana already, about 3 times a month, right?
Maybe 14. I was old for my age, and I believe I stated in the evaluation that it escalated to about 3 times a month.
Okay. But at that age, right?
That was over the course of some years. It was not easy to obtain when you're 14 years old.
Okay. And you were also talking about your use of alcohol during that time period, so it was marijuana and alcohol around that time?
Correct.
Was that the first time that you had, in 8th grade, was that your first time you started drinking and smoking marijuana?
The first time I tried cannabis and the first time I tried alcohol was in the 8th grade, yes.
And then you recall telling Dr. Lockton after the Arizona incident you left pot behind, right?
Correct.
Do you recall reporting that you've experienced very few cravings? Do you remember that?
I believe I said thoughts to use, but you could interpret that as cravings.
Okay, so you don't think you use the word cravings?
I don't think so, but I might misremember.
All right. At that point, it was from 8th grade, from age 14 to about age 29 or 30. By the time was your use of marijuana over that time period consistently increasing?
No.
Did it fade off and go away for a little while, or were you always?
I'd say it ebbed and flowed. Certainly I was not using in response to the arrest for the summary probation periods.
Now, as you just mentioned, that marijuana is now legal in California. Is there any possibility that you might revert back to using marijuana?
Not while I'm licensed and not while it's federally illegal.
Okay. Let's talk about your Washington conviction. You recall the evening of January 13, 2006?
I do.
And by my calculation, you were approximately 24, 25 at that time? Is that
Correct.
right?
Yes.
Was that the first time you'd driven with alcohol in your system or after you'd had a couple drinks?
It was the first time I'd driven after binge drinking.
How do you describe binge drinking?
For a man, 5 or more drinks in a period of 4 or less hours.
Did you obtain that from somewhere else?
I believe that is the NIAAA definition of binge drinking.
Thank you, I'm not a psychologist. So 5 drinks in less than 4 hours, you said?
Correct.
All right. Was that the first time you'd ever been evaluated for possible DUI?
You mean by a peace officer?
Correct.
I've never been evaluated for DUI other than that incident.
Okay. Do you recall why you were stopped?
The headlights were not on.
Do you recall where you're coming from?
I was leaving a bar.
And you said you were binge drinking, so by your recollection, you had 5 drinks that night, right?
4 beers and 1 shot.
Do you recall telling the officer you only had 2 beers?
Initially, yes.
Why do you think you told him only 2 beers?
I was a little bit scared and hoping that I would not get arrested for a DUI.
Did you know at the time that you probably should not have been driving?
I believe I said that just an hour or 2 later when in the police station.
Okay. And you mentioned earlier your BAC was determined to be approximately 0.15%, right?
Correct.
That was taken an hour after your driving, so you're familiar with how alcohol absorbs into your body and burns off, correct?
Somewhat.
Would you concede that your BAC at the time of driving would have been higher than a 0.15%?
I would concede that that's possible.
Earlier you said it was almost twice the legal limit, but per se, you would say 0.07 would be legal, 0.08 would be illegal, right?
0.08, yes, is the legal
Illegal.
illegal cutoff to my understanding.
So at a 0.15, you are over twice the legal limit, correct?
That's one way to put it.
Okay. Would you agree that driving while under the influence of alcohol is dangerous to yourself, others, and the public?
Yes.
After the officer evaluated for DUI and you did the breath test, he placed you under arrest for DUI and did a search. Remember that?
I do.
Do you remember him locating marijuana and a pipe in your pant pocket?
I do.
Were you smoking marijuana that night?
No, I was planning to later.
Okay. So then you were arrested for DUI, possession of marijuana, and possession of drug paraphernalia. And similar to the Arizona case, you were charged in criminal court with misdemeanors. Is that right?
Correct.
And then you pled guilty to possession of drug paraphernalia and then a reduced charge of reckless driving. Is that right?
Correct.
Criminal probation was for 2 years. Were there terms of probation, did they include a substance abuse course?
Had a DUI course, a MAD course, and a substance use evaluation, to my recollection.
Did you complete all of those?
Yes.
And termination was completed in 2 years?
Yes.
Did you abstain? Were you required to abstain from alcohol during that time?
I did abstain, and I believe the language was something to the effect of avoid alcohol.
Avoid alcohol?
Yeah.
Just in general or while driving?
In general.
In general. So you did abstain for the 2 years?
Yes.
And then when you were on probation with the board here, you were also required to abstain from substances similar, correct?
Correct.
So is it fair to say from 2006 to 2008 for the 2 years on criminal probation, and then from 2016 to 2018 in this case, you've abstained from all alcohol and marijuana use?
From 2006 to 2008, I abstained from both, yes. From 2010 on, I've abstained from cannabis. From 2016, during probation, I've abstained from everything.
2016 onward?
May 12th, 2016.
May 12th. Thank you. Now, when you talk about your drinking pattern and abstaining, when you were talking to Dr. Lockton, you mentioned not being allowed to drink as a condition of probation in comparison to refraining from marijuana. You said not being allowed to drink was more difficult. Do you remember using those words?
I anticipated it would be. I had 6 years of abstaining from cannabis under my belt at that point, so.
So at that point, when you were talking to her, you weren't saying that it was more difficult, that you just anticipated that it would be more difficult?
Yes.
Could you explain why?
I was occasionally having a few beers leading into the evaluation. From 2008 through 2016, I occasionally had alcoholic beverages without any issues. Certain events, nice dinners or Christmas with family, as I believe I noted in the evaluation, are situations where the people around me have a drink or two, and I otherwise probably would.
When you say occasionally, could you describe the frequency?
Of my drinking?
Back then, prior to that?
Probably somewhere between 1 to 3 times a week. I'd have somewhere between 1 to 3 beers.
1 to 3 times a week, and then 1 to 3 beers?
Correct.
Per sitting?
Correct.
Okay. And have you found it to be difficult to refrain from drinking alcohol during this last 2 years?
For the most part, no. There's the occasional time where I have a thought that it would be nice to be able to have one, but I certainly wouldn't describe it as a physiological craving.
Let's talk about your probation with the board. You entered into a stipulated settlement where you admitted the complete truth and accuracy of all the charges and allegations. Did you disagree with any of those? I know you signed it, but...
I don't disagree with any of the allegations.
Okay. And you agreed to being placed on 4 years probation, right?
Correct.
And the terms and conditions included the psych evaluation that we've mentioned, the practice monitor. Dr. Horvath was your practice monitor, right?
Correct.
Alcohol and drug abuse treatment program, and an ongoing treatment program?
Correct.
And then the abstention with the biological fluid testing, right?
Correct.
And then did you also attend an ethics course?
I did.
Earlier you mentioned a shift in your attitude as probation has gone forward. So you described it as a rejection to frustration to gratitude. And I'd like to just explore that a little bit more. When you say rejection, was that at the beginning of probation?
Yes.
Could you describe what it was that you were rejecting?
Well, there was the part of contemplating not pursuing licensure, so rejecting getting my license entirely, and in doing that, declining the offer of probation.
Okay. So it wasn't a rejection of the terms after you were placed on probation. So it's a rejection prior to being placed on probation and signing the stipulation?
Yes, before signing the stipulation.
Okay. Then at some point you change your attitude and decide you're going to sign the stipulation, agree to the terms. Is that where the frustration comes in?
Yes, initially I was frustrated.
What were you frustrated with?
As I noted in the psych eval with Dr. Lockton, I felt like I was being punished twice after I had already gone through the legal requirements. And then here I was, some years later, being subjected to scrutiny once again.
Then did you eventually come to gratitude, right? You
Yes.
said it shifted from rejection, frustration, then gratitude. Do you have a time estimate as to about when that shift in attitude happened?
Well, initially, there was gratitude involved because the shock or fear of the psych assistant application being denied was difficult to adjust to, the possibility of all of this work, being for nothing. So upon the issuance of the psych assistant license, there was already gratitude. But I would say that it certainly deepened and the frustration waned as I continued to work through the difficult emotions of the process that have resulted in primarily a feeling of gratitude for the opportunity and for having been given a chance. Because the board could have easily said no and not given me a chance, and that would have been very difficult, so I'm very appreciative.
Okay. Did you agree with the terms of probation? Did you find them to be appropriate and necessary?
I generally agree that they were fair, appropriate, and necessary, yes.
Generally, but not specifically?
If I were designing them, I might do a few things differently.
Okay. Were there a few terms that you felt were unnecessary and you just did it because, you mentioned earlier, you said something about checking the boxes. So did you find any particular term to be unnecessary as it applies to you, or?
I wouldn't say unnecessary. I think with the state of drug testing, there might be a way to test more with fingernails and hair than the urine testing. That might have been slightly easier for me to navigate on a day-to-day basis, but that's fairly inconsequential.
So is it more about the way the terms were carried out than necessarily what the terms were doing, what the goals of the terms were?
That's fair to say.
Okay. Do you continue to plan with it, do you plan to continue with any of the treatment that you've been undergoing during probation if your petition is granted?
Yes, I work very closely with Dr. Horvath. He runs the practice that I practice in. We see each other all the time. An hour of monitoring is far less than the amount of time that I spend consulting with him. I think it's an ethical obligation for psychologists to continue their own work throughout their life, so I will always go to analysis, probably about once a month, maybe a little bit less, but certainly more in times of stress.
You say analysis, is that, I'm unclear of what it is that you'd be continuing. So
Psychotherapy.
Oh, I see.
I'm also actively involved in the Smart Recovery community. I attend meetings now. I have a facilitator certification. Once off probation, I plan to facilitate meetings rather than attend them.
Okay. Would you agree that being on probation has proven to be beneficial?
Yes.
Would you agree it's assisted in your rehabilitative efforts?
Yes.
Do you believe remaining on probation with the board could have any continued benefit towards your rehabilitation efforts?
Yes.
Could you describe how it could have a continued benefit?
I would see it as a continuation of gaining acceptance through adversity. There's been a number of things that I've gained from the process as far as acceptance goes, like I noted in my petition, it deepened my empathy for some of the scrutiny that other clients go through. And just in general, I think there's always something to be gained from not getting our way.
Thank you. No further questions.
Thank you. At this point, Doctor, some of the board members may have questions. So if you can just state your name before you ask your question, so the court reporter can do that. Thank you.
It's Lucilla Quabadu, not at this time.
Thank you.
Jacqueline Horn. Dr. Camlin, I'd just like to ask a couple of questions. You did answer it, but I'd like to hear a little more specifically how you feel that probation has benefited you.
Well, like I said, my initial reaction was one of rejection and more frustration. So to work through difficult emotions rather than go with my initial reaction, it's helped me understand also through my analysis. I might tend to have a bit of an affinity more towards the rebel archetype. So conformity probably means I have more to learn in that respect rather than any sort of rebellion. So it's given me an experiential opportunity to work on that.
Okay. And you said earlier that you wouldn't call yourself an alcoholic, and I do appreciate the person first distinction you made, but it does sound like you're actively involved in 12-step or recovery programs.
Not 12-step, SMART recovery. And in SMART recovery, it specifically says in the workbook that participants are not required and even encouraged not to label themselves addict and alcoholic. It's part of the unconditional self-acceptance.
Okay. Okay. Thank you. That's it.
You're welcome.
Thank you.
Alita Bernal, I don't have any questions at this time.
Good afternoon.
Hello.
Stephen Phillips. I just had a couple questions. So, if I understood correctly, you don't intend to resume smoking marijuana as long as it's a federal crime?
And as long as I'm licensed as a psychologist.
Okay. So, your golden years are going to be spent smoking marijuana for...
I'll see when I get there.
Yeah, there you go. Do you intend to resume drinking?
Not during the course of probation. At the end of probation, even if it's the full time, I've committed to the full 4 years regardless of the outcome here. At the end of the 4 years, I plan to sit down with my psychologist, go through one of the main SMART tools, the cost-benefit analysis, and look at the possibility at that time, but not for the entire 4 years that I've agreed to be on probation regardless of the outcome today.
Okay. You talked about the fact that you engaged in binge drinking. Is that correct?
I did.
Okay. And are there times where people that engage in binge drinking historically might have been labeled an alcoholic, but now would be labeled as having a substance use disorder?
There are definitely people who probably would have labeled people who binge drink as an alcoholic, yes.
Right. And now, under substance use disorder, can binge drinking rise to that level?
Binge drinking can absolutely rise to a diagnosis of alcohol use disorder, yes.
Okay. How often did you engage in binge drinking?
The probably most frequent period was in my late high school years. It was weekends. I played basketball, so I had to at least keep things together somewhat. Probably my senior year was the heaviest period, and it was probably, I'd say 2-ish weekends per month.
Okay. I noticed on, let me just get you the document number so you can look at it. AGO 0037. It's page 40. Have you found the document?
AGO 0037?
Yes.
Yes.
In item number 1, where you're talking about your convictions.
Yes.
You use the word, I signed a plea deal.
Yes.
Correct? For both of those?
Yes.
Is there some reason why you didn't say I pled guilty?
I didn't think of a distinction between the two.
Were you guilty of both those crimes?
Absolutely.
Okay. And as to those crimes, what dangers, beyond dangers to patients, what dangers were intrinsic to those crimes?
Especially the DUI put everybody in the public in severe danger. Of course, to my relationships and things like that, there was definitely some damage to repair, but the greatest risk was posed to the public.
Okay. Why do you think we put you on probation?
Well, the primary reason is to ensure the safety of the public, and to ensure that if there were any ongoing issues with substance use or anything else, I was addressing those, but to make sure that I was safe to practice.
Good understanding. So if I understand correctly, you have been engaged in SMART recovery as a participant, not as a facilitator.
Correct.
You've been trained to be a facilitator.
Correct.
And you now intend to become only a facilitator.
Correct.
Okay. But you intend to remain abstinent for the full 4 years.
Correct.
Okay. I don't think I have any other questions at this time.
Thank you. Sir?
Hello, Dr. Camlin. Michael Erickson.
Hello.
I appreciate your thorough and concise summary of what you've been through and your efforts at rehabilitation and complying with the terms of probation. I wanted to ask a couple of questions. Some things that you mentioned at different points, and I'm not sure if there's a theme here or not, and if the theme is even important. You mentioned that you're pretty clear that you're not an alcoholic in the definition of that term, and that may very well be true, and I don't really know much about the SMART program. You did mention that they support not labeling people that participate. Earlier, you talked about some difficulty following laws, general or specific, and recognizing that following them is probably important in terms of being a good psychologist. You also mentioned something about maybe at first some difficulty with some of the terms of probation or being on probation in general. You also mentioned that some of your Jungian work and analysis suggests that you might be a rebel archetype. So together I'm trying to weave what I suppose is an obvious theme of maybe some tendency to be a rebel or bristle against authority. In the context of also being very appreciative and having gratitude for what you've learned to accept or submit to. And can you say anything about your process in this area, if it's even something that seems like an area that you're working in?
Sure. Well, I think the shortest thing to say is that, through the Jungian work, it's clear that the ego's function is to hold the tension between opposites. If I identify more with a rebel archetype, then probably there's more work for me in working on conforming and obeying. And generally, I think that's what I've learned as I've grown up and matured. This was certainly more something that I think I struggled with when I was younger. I think a lot of it stems from some emotional difficulties after my parents' divorce. My dad raised me on Star Wars and the rebels are the good guys. So there's just some learning from childhood that goes along with that. But it's pretty clear to me that I have a lot more to gain from conforming and following the rules, and that I'll be more effective in perhaps contributing to changes I'd like to see in the treatment of substance use from within than from the outside.
Good. Do you think, and I thank you for your thoughts and your answer on that. Do you think there, I don't mean this to sound like a loaded question, but it may have a sense of that. What else is there for you to learn if you're to remain on probation?
Well, just generally dealing with disappointment would be a big one, and continuing to I would take it as a sign, I don't know if you want to say from the universe or what, but from some power greater than myself, that I had more to learn in this particular area, and through the experience of the scrutiny of probation. And I would remain open to what I could gain from that through the process.
Good, thank you. No further questions at this time.
Thank you, ma'am.
Hi, Dr. Camlin. It's Cheryl Kasuga. What was the most difficult thing for you to follow, or what was the most difficult about your experience while you were on probation for the past 2 years?
I think the most difficult part was the struggle of whether or not to sign on. Once I made the decision to sign on, it went pretty well. Like I mentioned before, the occasional, like when I go home for Christmas and I'm with my family, to not have a glass of wine with Christmas dinner, it's not a horrible challenge, but it is a little bit irksome.
Why was it difficult to, why did you struggle with signing on and like contemplating at the start whether to continue or to even go on probation?
Well, like I said before, there was a part of me at least that reacted to it like I was being punished a second time. I'd already gone through the legal stuff, and I felt like I had put this behind me, and then here it was in front of me again. But I certainly came to recognize and appreciate the board's position that it's a privilege to practice, and it's probably worthwhile to vet me a little bit more before you just give me an unrestricted license.
And I guess why should we grant early termination of your probation?
Well, outside of the points I made in the initial statement, I think the certainly the nature and severity of the acts that led to my probation were severe. But since those, there have been no further acts, and the time elapsed is significant. And I believe I've already mentioned some significant evidence of rehabilitation. Nothing, there's nothing to suggest, or no evidence, and there hasn't been any risk that I've ever posed while practicing. Like I said at the end, I think it would be, to me, very meaningful to acknowledge how far I've come in the past 13 years, and it would be very much appreciated for me to get the acknowledgement of the board of my efforts over the years. And I believe that I am safe to practice and without risk, and I think there's a lot of evidence to support that.
Thank you so much. I appreciate your answers.
You're welcome.
Thank you. Any additional questions from board members?
Yes, I do have an additional question. Thank you.
Yeah.
Lucilla Quavidu, and thank you very much, Dr. Camlin, for your thorough description. Just three questions, really. What is your definition of without, not the textbook definition, but your definition of an alcoholic, and what is the difference? Well, I'll let you answer that first.
I conceptualize, well, one, I wouldn't use the term alcoholic. But if it's going to be used, I would conceptualize it as, this probably is more technical than you're looking for, but as the most severe form of alcohol use disorder. So there's mild, moderate, and severe, 6 or more criteria for severe. I would probably start to move into, I think, what people are driving at through the term alcoholic, as maybe 8, 9, 10 of the criteria. So the most severe of a severe use disorder, which is consistent with the Surgeon General's report from 2016, which classifies addiction as the most severe form of a substance use disorder.
Okay. And what is your definition of binge drinking?
I agree with the NIAAA definition of 5 or more drinks for a man in 4 hours or less.
And I think, well, 2 more questions, and then I'll be done for it. the first, you mentioned about activities. What are some of your activities? I noticed you mentioned bike riding, playing guitar. Do you do these activities with other people, or do you do these activities alone?
Both.
Okay. And last question. And I know, or did I hear this correctly when you mentioned that perhaps going home for the holidays, that having a glass of wine might seem a little irksome? Was that the word that you used?
That was the word I used, yes.
Yes. Why would that be the case for you?
Well, when you're the only one not participating in a family event, it can feel a bit lonely. And I believe in the line of thinking that the opposite of addiction is not sobriety, that the opposite of addiction is connection. So it results in me feeling disconnected from my family.
Okay. And you consider partaking in, and this is really the last question, you consider partaking in a cheerful, having wine as part of a family event? I'm asking.
It is part of our Christmas dinner, yes.
Okay. Thank you very much.
You're welcome.
That's all.
Thank you. Any other questions from board members? Any additional cross-examination questions? Anything additional you want to say, Doctor?
Just thanks again for your time and consideration.
Thank you. I'll now let the Deputy Attorney General make a closing statement.
As you all know, rehabilitation is a state of mind, and the amount of evidence of rehabilitation required will vary according to the gravity of the misconduct. The more serious the misconduct, the stronger the petitioner's showing of rehabilitation must be. And while fully acknowledging the wrongfulness of his past actions is an essential step, it is not the only step. As case law provides, the mere expression of remorse does not demonstrate rehabilitation. Rather, a truer indication would be sustained conduct over an extended period of time. This evaluation is not satisfied just by counting the correct number of years, but rather evaluating his conduct over this time period. A person seeking reinstatement must demonstrate stronger proof of their present integrity than one seeking admission for the first time, and he must show the most clear and convincing evidence that efforts made towards rehabilitation has been successful. Petitioner believes his probation should be terminated early because he has complied with all the terms of his probation and has come to terms with his use of both marijuana and alcohol. However, while he has complied with his criminal probation and has complied with the board's probation, what has he done beyond what has been required of probation? He shows a proper attitude, that he's gone from rejection, frustration, and ultimately gratitude. However, at what point in time did this gratitude step in? Was it a month ago? Was it 6 months ago when he applied for early termination? Or was it for the full 2 years that he's been on probation? I would submit that he has failed to affirmatively demonstrate the required showing that he is entitled to early termination at this time. It's only been 2 years of the 4 years of probation that he previously agreed to, when his convictions were approximately 5 years apart. I would submit that the board should only grant his petition if the board can confidently and without hesitation determine that he is fully rehabilitated. And if there is hesitation, then his petition should be denied. Thank you.
Thank you. Doctor, your closing statement.
I would just say that I feel I've submitted evidence far beyond checking the boxes of probation. I've been certified in multiple evidence-based areas of substance use. I chose to go to individual psychotherapy rather than attend SMART meetings. I go to SMART meetings on the off weeks, but I think it's pretty well agreed upon that individual psychotherapy is a more intensive form of treatment than just going to meetings. I've already mentioned a number of other things. I won't rehash them all that I did above and beyond the checking the boxes of probation. In addition, I would also mention that Ms. Shields is, I think, referring to Flanzer versus the Board of Dental Examiners and Houseman versus the Board of Medical Examiners, both case laws that are often cited in these hearings where those asking for reinstatement are in a position of a fallen licensee. So stronger proof of present honesty and integrity is needed than when seeking admission for the first time. I think it's important to reiterate that my misconduct occurred before practicing psychology. Thus, I would not consider myself in the position of a fallen licensee, rather a human who fell and whose recovery included ascent to licensure. Thanks.
Thank you, sir. With that, the matter is submitted and will go off the record.
We will be going into closed session now, and during closed session, we'll be discussing the petition hearings that we heard today, as well as some other disciplinary matters. We do not intend to come back together again. We'll be going back into open session, but simply for the purposes of adjourning the meeting. So it won't be necessary for anyone to hover or wait for the meeting to resume. Thank you very much.
Thank you.
Oh, that's a very good point. Thank you for reminding me. Tomorrow morning, we're going to go back into closed session first thing because of the process of the executive officer's evaluation. So I would say at the earliest, I would be here at 10 o'clock.